important aspect. So, if a powerful organization, that is the state, is given power to make laws for us, and it is making such laws which is taking our life arbitrarily, unnecessarily, unnaturally, then definitely is a very uh, just a serious constant. You know, in the civilized country, just like in some of the countries, the death sentence is not the sentence anymore. There are few countries in the world where you will not find any death sentence और फांसी की सजा आप नहीं पाएंगे कुछ देशों में. Why it is so? Where I cannot give you life, how can take your life? It is the contention of those countries. Now they say that it is the society which created such situation in which I committed a crime. So society is equally responsible for making me criminal or making anyone criminal. So society should also be punished if anyone is doing any crime. Then this question arises that how can I take one's life if he has committed some crime? And when I cannot give him life, I can how can I take his life? So some countries has vanished the death sentence or phansi from the sentence list, but India is one of those countries who's still having the death sentence, one of the sentence. So Article 21 is becomes very important article of this constitutional law, and it talks about mainly three words. One word is law. Naturally, being the law student, you will again and again encounter from this word what is the law. Again and again, you will have to ask from yourself this question: what is the law? And again and again, you will definitely get the different answer about the connotation and the means of the law. Not same answer always. Whenever you will ask what is the law, every time it may be that you will get the different answer. What is the law? Sometime you will jump into the sociological law. Sometime you will jump in the analytical law. Sometime you will jump on the natural law. Sometime you will just jump on the realist law. Sometime you will go on the religious law. Sometime you will go on the moral law. So different time you will got the different answer. So the definition of the law is not so easy one. So firstly we will see what is the law in this article. Thereafter we will see what is the personal liberty, and thirdly we will see what is the procedure established by law. So in gist or in summary, if we talk about this article, because later we will elaborate that, but firstly let us understand this article summarily. And before Maneka Gandhi case, meaning thereby the constant view of Article 21, that can also be the correct word for it. आर्टिकल 21 का सीमित नजरिया. आप किसी चीज को सीमित करके देखेंगे, सर तो पढ़ाना जानते ही नहीं है, कोई कह रहा है सर तो बहुत पढ़ाना जानते हैं, तो किसी ने कॉन्स्टेंट कर लिया, किसी ने उसको इलेबोरेट कर दिया, वाइड कर दिया. तो कांस्टेंट व्यू ऑफ आर्टिकल 21 अगर हम देखेंगे बिफोर मेनका गांधी केस, देन वी विल फाइंड लॉ मीन्स, और लॉ मीन्स इज द लॉ only state made law. The law is made by the state is the law only. So this is the limited definition of the law, that only the state is making, that is the law. It is true that state makes the law, but it's not the complete truth. Law also imbibes in itself the principle of natural justice. The facet or the aspect of the morality is not ignored by the law too, you know very well. Similarly, the customary rules which is prevalent in any particular society is not ignored by the purview of the law sometimes. So you cannot ignore the custom, that is also the law. Similarly, the rules which is not beneficial for the society but is beneficial for the powerful person or the state or the sovereign may be the law that is not beneficial to the society. So that is also the objection towards the law at such type of law which is not beneficial for the society cannot be the law at all. So such types of law also. But law means in this purview which we are talking about over here. Okay, what is the law? Before Maneka Gandhi case, it is said that law is the law which is made by the state only. Only is the state is the maker of the law, meaning thereby we the people who are very poor one, who are very just nasty one, who are very just weak one, has given our power to the state and surrendered his power to the in favor of the state and said that you make the law for us and we make the state powerful, we make the king powerful, and that powerful entity organization that is the state is making law for us is the law. This was the view before Maneka Gandhi's case. But later you know that after Maneka Gandhi case the situation changed and this view was not accepted at all. It was said that the law should embody the principle of natural justice too, meaning thereby, if I am making law for myself, for my benefit, that is not the correct law, appropriate law. That should not be within the purview of the law, within the definition of the law, because I am making the law for my benefit. If a powerful person, that is the state, is making law for his benefit, not for the benefit of the society, that cannot be called a law at all because that is not having the principle of natural justice. So this was the wider view later adopted after the Maneka Gandhi case. Second important word which we will discuss today is the procedure established by law. What is this procedure? You know that I make the procedure that you will not write in my class, you will not do anything in my class. That procedure is law because I am making that law and I am a sovereign person. I'm a state. I'm the representative of the state. I'm that is the university. University is the state. University is the powerful entity, organization, and I'm representative of him. If I have given the power to make law, then definitely I can make the law because you know that the sovereign makes the law as well as the representative of the sovereign can make the law. If I delegate my power to you that you handle this class, then definitely you are the lawmaker. So procedure established by law, what is this? Before Maneka Gandhi case, this was again a debatable question. So this was only means the procedure established by legislature. The law, प्रोसीजर द प्रक्रिया जो कि विधायिका ने बनाई है वो प्रक्रिया विधि द्वारा स्थापित प्रक्रिया कही जाएगी. दिस वाज द व्यू बिफोर मेनका गांधी केस. If I have made the law, law is right, wrong, correct, incorrect, whatsoever it is, that is the procedure, and that procedure should be adopted, which I told you while following the law. If there is any law, the procedure may be wrong or right, but that is the procedure because the legislature has made. So the procedure established by law is the procedure, and that cannot be denied at all. You will have to follow the procedure, otherwise you will be punished. So this was the meaning of the procedure established by law of the term which is used in Article 21. You know very well. Thereafter, the third, later the wider view of this procedure established by law came, and you know that it was said that this procedure must satisfy the requirement of the justness, fairness, and reasonableness. If I am making a procedure, then that procedure must be just, fair, as well as reasonable one. If that's not just fair and reasonable, definitely uh, any person is not bound to follow that. You know that So many laws was not followed by the Indians during the independence movement, Namak Satyagraha, Dandi Yatra, so many things which was not followed. That was the laws at that time. So the procedure established by law is not called a procedure until it is having the justness, fairness, and reasonableness. So only that procedure can be called the procedure which is just फेयर एंड रीजनेबल. मैंने मैसेज कर दिया आधे घंटे बाद आपको उधर जाना है, ये कोई तरीका है? यू शुड मैसेज बिफोर 1 आवर. इन्होंने टेल कह दिया आज मूड कोर्ट की तैयारी कर रहे हैं. दिस इज प्रोसीजर. द प्रॉपर procedure should be followed. That then only the procedure can be called a just procedure. So this was the wider view which was adopted after the Maneka Gandhi case and in Maneka Gandhi case too. Later, third important word is the personal liberty. So personal liberty before Maneka Gandhi's case was the meaning only liberty of the physical body. You are physically free, but you are mentally slave. You are physically free, you can go anywhere, but there are some psychological fear in your mind. You cannot do this, you cannot do that. Though that is the correct thing, which is denied by someone, but you are physically free. You can go anywhere, you can do anything, but mentally you are having some psychological fear. If I will do this, what will be the consequence of this? That's why you are not totally free. So personal liberty, only liberty of the physical body, it was the view before Maneka Gandhi case. If I am physically free, then I am free. Everyone will say I am free, but mentally I am not free. There are some burden, some liability, some fear in my mind. Then definitely I should not be called a free person. So Article 21 exclude freedom dealt in Article 19. You know, earlier this I teach you Article 19. So Article 21 exclude freedom dealt in Article 19. Article 21 में आर्टिकल 19 की जो आज़ादी है वो शामिल नहीं है या उनको बाहर कर दिया गया है. ये बात थी मेनका गांधी के केस से पहले कि आर्टिकल 21 एक्सक्लूड फ्रीडम डील्ड इन आर्टिकल 19. आपको आर्टिकल 20 में नहीं है, आप घूम फिर रहे हैं, आज़ाद है, फिजिकल आपको लिबर्टी है, बोलेंगे नहीं, यू कैन नॉट स्पीक. आपको ये नहीं बोलना है, आपको बोल नहीं बोलना है, आपको इधर नहीं जाना है, आपको उधर नहीं जाना है, आपको उसके साथ नहीं बैठना है, आपको उसके साथ नहीं बैठना है, ठीक है ना, आपको ये व्यापार नहीं करना है, आपको आ, यहाँ पे मकान नहीं बनाना है. तो आर्टिकल 21 एक्सक्लूड्स फ्रीडम डील्ड इन आर्टिकल 19. 19 वाली फ्रीडम अलग चीज है और आर्टिकल 21 वाली फ्रीडम अलग चीज है. दिस वाज द व्यू ऑफ द before Maneka Gandhi case. But later, you know, the in Maneka Gandhi case and after the Maneka Gandhi case, this view was changed, and it was said that the personal liberty include right to live with human dignity. पर्सनल लिबर्टी इज नॉट द लिबर्टी ऑफ द फिजिकल बॉडी. मुझे आपने केवल जेल में बंद नहीं किया, कमरे में बंद नहीं किया, ताला नहीं लगाया, आजाद नहीं. दिस वाज नॉट द व्यू. लेटर बाद में ये कहा गया इट इंक्लूड राइट टू लिव ह्यूमन डिग्निटी. ठीक है ना, मैं इनसे बात करना चाह रहा हूँ. देयर आर सम कॉन्सेप्ट आई कैन नॉट say so. There are something which I want to express, I am not able to express that. So I am physically free, but I am not living the life which include the life uh, ingredients. So it was said after the Maneka Gandhi case that Article 921 includes and Article 14, 19, 20 are mutually exclusive. So they are not mutually exclusive. It was said Article 14, 19 and 21 are not mutually exclusive. आप इन दोनों तीनों को अलग नहीं कर सकते हैं. You cannot exclude Article 19 from Article 21. You cannot exclude आर्टिकल 14 फ्रॉम आर्टिकल 21। जब भी आप आर्टिकल 21 का नाम लेंगे तो आर्टिकल 19 की जो आज़ादी है उसमें अपने आप शामिल हो जाएंगे। आर्टिकल 19 में बोलने का अधिकार, घूमने फिरने का अधिकार, संघ बनाने का अधिकार, ये सारी चीज़ें अपने आप 21 में, और बराबरी का अधिकार जो 14 है वो भी आप इसमें शामिल मान लेंगे। इन तीनों को अलग करके एक करके देखें। तो दिस वाज द जिस्ट ऑफ